FORA.tv. The world is thinking.
The third civil rights case was Reekie versus New Haven, a case involving a city that had tossed out the results of firefighter promotion tests because white candidates did overwhelmingly better than minority candidates. The white and Hispanic firefighters who had passed the exams were thus denied promotions and sued for employment discrimination under Title VII of the Civil Rights Act of 1964. New Haven responded that it had to start the process over with new tests because it otherwise would have been sued under Title VII by the passed-over firefighters because of the disparate racial impact of the tests. Besides, it argued, no one was promoted and therefore no one had been the victim of discrimination. You see what kind of arguments these cases require people to make. The Supreme Court, as you know, reversed. In a somewhat strained 5-4 opinion by Justice Kennedy, the court concluded that New Haven could not throw out those test results and thus intentionally discriminate against the white firefighters who had passed the test unless it had a strong basis in evidence to believe that failure to do so would subject it to disparate impact liability. Finding that New Haven could not have been held liable for the results of its job-related tests, the court found no legitimate basis for discarding the tests simply because of an unwanted fear, an unwarranted fear of litigation. Justice Scalia's concurrence made the point that the court's resolution merely postpones the evil day when the court will have to confront the question whether and to what extent the disparate impact provisions of Title VII are inconsistent with the prohibition of disparate treatment under the Equal Protection Clause of the 14th Amendment. In other words, when may an employer intentionally discriminate against one race to make up for test results or other procedures that produce a disparate impact on another racial group? As he said, that evil day is going to come when the court is going to have to resolve that question. The court's Reekie decision, as you've all read, overturned a one-paragraph Second Circuit panel summary affirmance of a district court summary judgment. A petition for rehearing en banc was denied on a vote of 7-6. The panel decision, the one-paragraph panel decision, included Judge Sonia Sotomayor, President Obama's nominee to replace Justice Souter. President Obama has said that the capacity for empathy was an important consideration in selecting her. It was therefore notable that in her dissent that she summarized in open court the day of the decision, Justice Ginsburg used that same word, saying that the higher-scoring firefighters understandably attract the court's empathy. When the printed version of the decision was released, however, the word sympathy was placed in the word empathy. Maybe it was there when she read it, but she used the word empathy. Justice Alito responded in his dissent that the firefighters passed over by New Haven were not interested in sympathy, but merely asked to be accorded the right, quote, even-handed enforcement of the prohibition against discrimination based on race.